Have you pleaded this, sir? Guilty or not guilty?
You guilty.
Are you pleading guilty because you are guilty? The point of the matter is that jumps out is he assaults this lady, but she is 5 months pregnant at the time. That's just off the chart, especially someone who's pregnant. Shame on them, especially pregnant with you.
What you just watched, that's Demon Sergeant Jr., surrendering his rights and pleading guilty. But what he calls just the mother of his child, the judge calls something much darker. What's really happening? This is Texas versus Sergeant Jr. It looks like a standard case of aggravated assault with a deadly weapon, but it's really about a brutal betrayal. Sergeant faces up to 20 years in prison for attacking a woman who was 5 months pregnant at the time. Why does the defendant downplay the victim's role so casually? And if this plea deal is considered customary, why does the judge describe his behavior as off the charts? Something here just doesn't add up. To understand courtroom psychology and see how a judge's moral compass can change the course of a sentence, hit subscribe for more insights. Now, let's go back to the beginning of this arraignment.
24 CR 2114 is now called the state of Texas versus Demond Sergeant Jr. That is you, present, with your attorney and the state's attorney. Does the defendant waive a Mr. Lodge, waive a formal reading of this indictment and arraignment? Can we proceed?
No waived, Your Honor.
In summary, then this indictment alleges, sir, that on or about September 25th, 2024 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with a deadly weapon. Do you understand what you're charged with here, sir?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500, and there will be terms and conditions of probation which are normal and customary for this type of offense.
Hopefully this is misunderstanding.
Do you understand this as the agreement?
That's quick.
If I follow this agreement, you have no right of appeal of your case. Do you understand? Have you pleaded this, sir, guilty or not guilty?
You guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney. Are the contents true and correct?
Yes.
Yes, they're correct. Yes, speak out.
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
Correct.
It's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
I am going to follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to defer or postpone any finding of guilt so long as you follow terms and conditions of probation, which are normal and customary for this. You will be placed on probation for 10 years. That can be shortened to 1/3 for good behavior and following the rules. You will be fined $500. And what is now the relationship? Do you have any relationship with this person?
That's just the mother of my child.
Just the mother of your child.
Yes, sir.
That's no little thing. That's important. So how are we going to work this out? How do we do this?
Well, there needs to be no contact. And as far as dealing with the child, they'll have to make arrangements through a third party.
That's understandable. What is the name of the victim? And Judge, with the no contact, we understand. Will he be released today?
Well,
Here.
we're going to deal with that just in a moment. there will be conditions of probation. Now, what concerns me, and I'm looking at this probable cause affidavit, is that I don't have a pre-sentence report. I probably ought to order a post-sentence report to look into conditions of probation, which are normal and customary. But the point of the matter is that jumps out is he assaults this lady who is the mother of his child, but she is 5 months pregnant at the time.
That's the child he's referring to.
Okay, Turner was 5 months, or okay, but she has been assaulted by her boyfriend, Devon,
That child was born after this
who
offense.
is
Judge.
5 months pregnant, advised that the assault started. Say that again, man?
There's no other child. He referenced a child.
Oh,
The child was
okay.
born after this event, Judge.
Okay, but the victim was 5 months pregnant.
Yes,
Oh, okay, that's the
Yes,
point
sir.
I'm making.
I'm sorry.
Yeah. First of all, it's inappropriate to assault anybody, much less someone who is 5 months pregnant. I mean, that's pretty low. No gentleman, no person should ever do that. That's just off the charts of appropriate behavior. And you knew the lady was pregnant, didn't you?
Yes, sir.
And Your Honor, it has been some time since that offense, and he has not had any behaviors like that since then.
Your Honor certainly can choose to.
What's in the past is never really in the past.
So,
That's a famous saying. And the fact is that what occurred, just like when we have trials here, what we do is we have to relive what happened before and figure it out. I'm going to ask for a post-sentence report. We'll come back. We'll get some more information because it's limited in the information I have, except for this 1-page probable cause affidavit.
Do you want to make it a pre-sentence and just
No,
withhold?
he's going to start on probation.
Okay.
I don't want to, so that there are terms and conditions of probation, which he's going to have to abide by, and he is responsible for it. Again, if you fail, your probation can be revoked. You can be found guilty and sentenced up to 10 years in prison. Do you understand?
Yes, sir.
All right. Please tell the jury we're going to need just a few minutes. Thank them for their patience. Thank you.
Yes.
And you shall also, you will be required to complete this batterers intervention program, which is normal and customary for this offense. And
it's wrong.
no man gets women, a lady. That's just off the chart, especially someone who's pregnant. Shame on them. Especially pregnant with your child. Shame on them. All right, we're going to come back. When can that post-sentence report be done?
Do you want me, we can expedite it if you want us to.
Yes, ma'am.
Okay.
About how long would that take?
We usually take them, it's usually about a month before we do them, but if you want us to do it earlier, we can.
If I reset this for 4 weeks, is that good?
Absolutely.
Thank you.
And you'll be on probation until then.
He begins probation immediately when he signs this document.
Okay.
Yes.
So he'll be released.
We have a verdict.
Thank you, Your Honor.
Thank you.
The decision is final. Demon Sergeant Jr. walks away with 10 years of probation instead of prison. But here's the question. Does a decade of probation actually satisfy justice for a pregnant victim? Comment below, Team Sergeant or Team Victim. Was the law right to be lenient, or was this a missed opportunity for real accountability? If this case got you thinking, hit like. Share this with anyone who loves courtroom drama. Next, a defendant who shocked everyone.